Welcome to the video. Today we will unpack a nuanced situation. Applying for a temporary U.S. visa, like the C1/D crew member visa, after a long absence from the United States as a former lawful permanent resident. First, we will set the context and clarify why an expired green card does not automatically end permanent resident obligations. Then, we will explore abandonment rules, Section 214B, hurdles, how to formally abandon LPR status with Form I-407, and the rare but critical possibility of derivative U.S. citizenship. Finally, we will wrap up with actionable steps, a checklist, and quick quizzes to reinforce your understanding. Here is our agenda. First, we clarify the difference between having an expired permanent resident card and still having lingering LPR obligations. Next, we examine the automatic abandonment presumption after 12 months outside the U.S. Then, we dive into Section 214B and the presumption of immigrant intent. After that, we cover the strategy of filing Form I-407 to formally abandon LPR status. Subsequently, we flag the rare scenario of automatic U.S. citizenship under the Child Citizenship Act. Finally, we provide a checklist, a decision flow, and some quick quizzes. To begin, remember that an expired physical permanent resident card does not automatically terminate lawful permanent resident status. If you have been outside the United States for extended periods, especially beyond 1 year, there is a strong presumption that you abandoned LPR status. This presumption exists regardless of whether your physical card expired. You cannot simply ignore the previous status when applying for a new temporary visa. Let us contrast permanent resident obligations with temporary visa requirements. First, an expired card does not mean your status obligations ended. Second, extended time outside the United States, particularly beyond 12 months, creates a strong presumption that you abandoned your LPR status. Third, the DS-160 application requires you to disclose prior LPR status, which flags potential immigrant intent to a consular officer. Fourth, the C1/D visa is strictly non-immigrant. You must persuade the officer that you will leave the United States after your authorized stay. Fifth, you cannot simply attempt to pivot from permanent resident status to a temporary visa without reconciling the prior status. Finally, we will discuss why proactively cleaning up your record can significantly strengthen a new application. This flowchart begins with assessing your time outside the United States. If the absence exceeded 12 months, the presumption of abandonment applies. Next, it asks whether you maintain significant ties to the United States. If not, abandonment is likely. From there, it suggests considering filing Form I-407 to formally abandon LPR status. In parallel, the diagram prompts you to check for potential U.S. citizenship under the Child Citizenship Act. If that applies, you should pursue a U.S. passport, and you do not need a C1/D visa. If not, it shows the path of filing I-407 and then preparing a strong C1/D application with robust home country ties and employer documentation. The end states highlight 3 outcomes: confirming U.S. citizenship, filing I-407 and improving your non-immigrant case, or skipping I-407 and facing a higher risk of refusal under Section 214B. Here is a practical sequence to file Form I-407. First, obtain and review the official instructions. Next, complete the form accurately, including your A number, departure dates, and reasons for relinquishing LPR status. Then, include evidence that you no longer reside in the United States, such as selling a U.S. residence or establishing long-term residence abroad. After that, submit the form to the correct USCIS or CBP address, according to the instructions. Subsequently, keep proof of submission or a receipt to present at your visa interview. In addition, prepare a short cover note to explain that you are relinquishing all immigrant claims. Finally, after filing, reflect this fact in your DS-160 and prepare documentation of strong home country ties. Section 214B presumes that every temporary visa applicant intends to immigrate. For former permanent residents, officers pay closer attention because you previously held the right to live in the United States. To overcome this, you must present compelling evidence of home country ties, such as close family, property ownership or lease, and stable employment. You should also present a clean travel history that demonstrates prior compliance with visa terms. Additionally, clarify the nature of the C1/D employment, including ship name if known, contract terms, port calls, rotation schedule, and a concrete return plan. A coherent narrative supported by documents will be more persuasive than general assurances. This comparison shows two approaches. On the left, applying for a C1/D visa without filing I-407 leaves the immigrant intent flag unresolved. As a result, the officer is more likely to find that you have not overcome the presumption under Section 214B, and your record remains ambiguous. On the right, filing I-407 before applying shows a deliberate relinquishment of immigrant claims. Consequently, your case narrative becomes cleaner and aligns better with non-immigrant intent, though you still must provide strong supporting ties and purpose documentation. This checklist organizes essential documents. Start with a valid passport. Next, include the DS-160 confirmation and fee receipt. Then, provide proof of I-407 submission to show you relinquished LPR status. Add your employer letter from the shipping company and your contract to establish the purpose and itinerary. Provide proof of home country residence, employment or income, and financial statements to demonstrate durable ties. Also include family evidence where applicable. Present travel history that shows compliance with prior visas. Finally, draft a clear cover letter that explains your I-407 filing, your temporary intent, and your concrete plan to depart after authorized stay. Now consider whether you might already be a U.S. citizen under the Child Citizenship Act. If, before turning 18, you had at least one U.S. citizen parent, you were a lawful permanent resident, and you resided in the United States in that citizen parent's legal and physical custody, you may have derived citizenship automatically. If so, you should obtain proof of citizenship, such as a U.S. passport or a certificate of citizenship, rather than applying for any visa. Bring evidence of the parent's citizenship, your LPR status, and your U.S. residence history to document your claim. If you are a citizen, you do not need a visa. Quiz time. The question is, after how long outside the United States is LPR status often presumed abandoned? The options are 6 months, 12 months, 24 months, or only when the card expires. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is 12 months. Staying outside the United States for more than a year typically triggers a strong presumption of abandonment of LPR status, independent of whether the physical card has expired. Here is the second quiz. The question asks, which single step best strengthens a C1/D application after years abroad as a former permanent resident? The options are telling the officer you lost your card, not mentioning prior LPR on the DS-160, filing Form I-407 before you apply, or booking a flight and asking for leniency. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is to file Form I-407 before applying. This action demonstrates that you have relinquished immigrant claims and helps align your application with non-immigrant intent, although you still need to present strong ties and a clear, temporary purpose. Let us consolidate the key points. An expired card does not terminate status obligations. More than 12 months outside the United States usually creates a presumption of abandonment. The DS-160 will flag prior LPR, raising potential immigrant intent concerns. Filing I-407 cleans up your record and supports a non-immigrant narrative. You still must present strong evidence to overcome Section 214B. Finally, always check first whether you might be a U.S. citizen under the Child Citizenship Act. In this Markdown walkthrough, we present a concise scenario for a former LPR who left the United States in 2017 and now needs a C1/D visa for a ship contract. The individual acknowledges prior LPR status on the DS-160. The action plan is to file Form I-407 and retain proof, collect robust home country ties, obtain employer letters and contract details, and prepare a short cover letter that clearly states non-immigrant intent and a return plan. Next, the applicant files the visa and prepares for a Section 214B interview. Finally, Before doing any of this, the individual should check whether the Child Citizenship Act applies. If it does, they should pursue a U.S. passport rather than a visa. To summarize, start by checking if you might already be a U.S. citizen under the Child Citizenship Act. If so, pursue documentation of citizenship rather than any visa. If not, file Form I-407 to formally abandon LPR status and thereby clarify your record. Then, prepare a strong package of home country ties and employment documentation to address Section 214B. Maintain consistency and transparency across your forms, letters, and interview answers. This content is for educational purposes only and does not constitute legal advice. Immigration decisions depend on individual facts and the discretion of consular and immigration authorities. You should consult a qualified immigration attorney for tailored guidance regarding your specific situation. Thank you for watching. If you found this helpful, please like, share, and subscribe. Share your questions or experiences in the comments, and let us know which part you want us to explore next. Your feedback helps others navigate similar situations.